This is part 3 with regards to the Idahofour motioninlimine hearing for the judge's rulings on a lot of these things. He did one document that talked about all of the things that he pretty much addressed at court and just kind of summarized them, and then we're going to move on to the new things. These are going to be the last two of the current document with summarizing all the things that happened in court and his justifications for why he did what he did, and then we're going to move into the new stuff. So make sure you hit that follow button. Let's get into it. If you have not seen parts 1 and 2, please go watch those below before watching this video. Now, seeing as these two are very important, I thought I'd do these two separately on their own. And this is regarding the state's motion for the admissibility of a demonstrative evidence. They want to build a not-to-scale 3D model of the 1122 King Road residence as a demonstrative exhibit at trial, contingent on the state laying sufficient foundation to establish the basic accuracy of the model and a demonstration that will be helpful to explain the testimony of the presenting witnesses. The state contends the model will aid certain witnesses in describing their testimony. Defendant objects, arguing the state's drawing of the model and any other related information was only recently disclosed in discovery in a file defendant describes as massive. Defendant claims the data model cannot reasonably be evaluated by its expert in time. Defendant disputes that the model is relevant, and even if it was, claims it should be excluded under IRE 403 due to the danger it might not be accurate. It says that the trial court has discretion in allowing the admission of demonstrative evidence, and that here the court finds the demonstrative exhibit is relevant, assuming foundation can be laid, because it will supplement the testimony of witnesses or assist the jury in obtaining a better understanding of facts and issue. It says the homicides occurred in 2 bedrooms within a 3-story home with a complicated layout. The suspect's ability to enter the home, carrying out the stabbings, and exit the home consistent with DM's observations will be a central point of the trial, particularly given the defendant is challenging whether it can be accomplished by one person within the time frame alleged. The model will aid the testimony of lay witnesses and experts alike in explaining the location of victims, witnesses, and other items of evidence, as well as an understanding of the suspect's potential or likely path of travel. And then he states a case saying that though it's not to scale, accuracy is not the standard governing relevant of illustrative evidence. Rather, the illustrative evidence must only be relevant to the witness's testimony, and he states State versus Stephen in Idaho. He also states State versus Rodenbaugh, which says, as long as the exhibit is not deceptive, it does not have to be shown to be precisely accurate or consistent with the testimony of other witnesses. He says that while defendant's expert, Mr. Nodell, contends there is a risk that the state's model could be misleading if it misrepresents the location of a wall or door or an actual line of sight, those are simply concerns at this point. The state intends to lay foundation to establish that the 3D model fairly depicts the residence, and if it fails to do so, the model will not be allowed. Further, defendant is free to cross-examine the testifying witness and to put on his own evidence, including experts. He may also use his own demonstrative exhibits if proper foundation is laid. However, the state is not going to be held to a standard of precise accuracy in this regard. It will only need to demonstrate accuracy to the point of avoiding deception. So he's saying there's no basis under IRE 403 to exclude the model. Defendant contends that allowing the model is prejudicial because it is built from data that was ultimately disclosed and which is untimely disclosed, and which is its expert has little time to analyze for accuracy. So he's saying because the state is not going to introduce the model as a substantive evidence, he doesn't think there's an issue here. He said, moreover, as discussed, Mr. Nodell's concern about his time constraints are based on his impression that he will have to analyze the underlying data to ensure the model's proper scale, dimension, and completeness. Again, accuracy is not the standard. Mr. Nodell need only assure himself the model is not deceptive, and there is sufficient time to do this given the August trial date. It says, to this end, the state is to make the model available to defendant as soon as it is completed and no later than the pretrial conference the motion is granted. The state moves to preclude defendant from offering any evidence in support of an alibi other than from defendant himself. The basis for the state's motion is defendant's failure to comply with the notice requirements governing alibi evidence. That's funny because they didn't give a lot of their evidence on time. It says, at this point, defendant has only provided notice that he was out driving in the early morning hours of November 13, 2022, throughout the area of South Pullman, Washington, and west of Moscow, Idaho. He intends to present testimony by his expert Cy to partially corroborate his alibi using CSLI data from defendant's cell phone. However, the alleged offense occurred between approximately 4:07 a.m. and 4:20 a.m. At most, Mr. Ray can opine as to where defendant's cell phone was up to 2:54 a.m. when it was apparently turned off, and approximately 4:48 when it began reporting to the network again. Defendant has provided no evidence as to his location at the time of the crime. In other words, he has provided no alibi evidence as contemplated by the rules. That said, the court will not categorically preclude defendant at this point from offering alibi evidence at trial. He states State versus Juarez. And whether to exclude late disclosed alibi evidence requires weighing prejudice to the states against the defendant's right to a fair trial and considering whether less severe remedies are sufficient. There are still 4 months until trial begins. If defendant does unearth alibi evidence, it is his obligation to immediately make the state and the court aware of it. At that point, the court can apply the Juarez standard. Excluding it at this time is premature, and therefore the motion is denied, subject to being re-raised if defendant does disclose alibi evidence. However, at this point, defendant has not provided an alibi, partial or otherwise. And there's one more, actually. It says state's motion for 404B evidence prior traffic stop. The state moves under IRE 404B for the admission of defendant's August 21st, 2022 traffic stop in Moscow, Idaho, during which he was stopped for speeding and issued citation for failing to wear a seatbelt. Specifically, the state seeks to admit the officer's OBV footage of the traffic stop as well as the citation. Argument is relevant to proving defendant's identity, vehicle ownership, and address and phone number. Defendant objects, pointing to Idaho Supreme Court case law stating that evidence of prior misconduct is relevant on the issue of identity when the evidence demonstrates sufficiently similar as well as distinctive characteristics or patterns between the prior misconduct and the charged crime. State versus Porter. Confusingly, defendant argues his prior traffic stop bears no resemblance to the charged crimes, therefore cannot be relevant to identity. He also argues it is unfairly prejudicial and may confuse the issues. Evidence of other crimes, wrongs, or acts may not be admitted pursuant IRE 404B when its probative value is entirely dependent upon its tendency to demonstrate the defendant's propensity to engage in such behavior. State versus Salinas. The court finds the evidence is relevant to establish defendant's identity and link him to the charged crimes. Indeed, the citation and footage up until the point defendant provides his phone number serve to identify defendant by name and physical appearance, phone number, and address. The evidence also establishes defendant as the registered owner and driver of the vehicle and make and model of which was thought to be used by the killer. Further, the evidence places defendant in Moscow at night on one of the dates of interest alleged by the state to be relevant to planning the charged crime. All these factors played a role in the investigation of the crime. While defendant cites to case law discussing identity under 404B as requiring strong similarities between the bad act and the charged crime, this is in the context of establishing identity through signature quality. The state, however, is not seeking to introduce prior traffic stop as established modus operandi, therefore defendant's case law and argument is not well placed. Upon weighing the IRE 403 factors, the only portion of the footage that the court finds troubling is when defendant inquires why the officer needs his phone number. This inquiry could be perceived by jurors as to be insolent. Given its lack of relevance and potential for prejudice, that inquiry shall be redacted. So they're not going to show him kind of saying, "Why do you need my phone number?" Says the defendant also contends it is unfairly prejudicial because the footage provides a clear shot of the defendant's vehicle, which may lead to the jury to believe it's suspect vehicle captured on surveillance videos at and near the crime scene on November 13, 2022. However, this is precisely what makes the evidence probative. It links defendant to the crime scene. While this may be damaging to his defense, it is not unfairly prejudicial when balanced against its strong relevance. Thus, the motion is granted with the noted redactions. So that's everything. Make sure you give that like and a follow. And now I'm going to move into the newer things that he just posted today.